Yes, Mr. Dingemans.
Thank you, my lords. We've got to dealing with the first of all the Mid-Counties case and then the Cumberland case. So just I had two further aspects of the legal framework, legal and policy framework that I wanted to touch on before coming to the documents that we're dealing with in this case. So first of all, if we could just go as a starting point, please, to the judgment below and the discussion of the conditions. The discussion of conditions it's paragraph 32 of the judgment below, which is page 72 and into 73. Here we've got the reference to mid-counties, excuse me, at the bottom of 72, and then the judge below goes on to say what the point we were touching on before lunch about the expert readership, and then says the author of the report noted that where...
So where are you reading from?
Sorry, bottom of page 72 of the bundle,
got you,
the
yes.
core bundle, paragraph 32 in the judgment below.
Yeah.
The difficulty of mounting a challenge of this nature, etc. And then the author of the report noted that where the claimant's objection noted what the claimant's objection had said. He considered whether it would be appropriate to impose any conditions on the grant of planning permission for the wall. No doubt he had in mind there was no need for him to set it out. The relevant test that any condition would have been necessary, relevant to the planning and to the development to be permitted. A wholly intelligible chain of reasoning on the issue of planning history, and the report doesn't mislead. That's a good starting point, just to bear in mind the legal principles. They are also highlighted, as I've noted in my skeleton argument, in relation to the rights case. So the rights case, which your lordships are no doubt familiar with, was a Supreme Court judgment last year concerning a wind turbine, again in the Forest of Dean district. That is in the authorities bundle. And the facts, again, are not...
Yes, I was one of the judges in the Court of Appeal, so I remember the case.
I had picked that up, my lord. Sorry, forgive me. So it begins at page 377 of the authorities bundle. It's the Supreme Court's judgment. Your lordship's obviously familiar with the case. The only reason for including it and the reason to point or why it's relevant for our purposes is the paragraph 34 there, where their lordships have considered the Newbury test in relation to planning conditions, first of all, and how that in fact also should encompass the ambit of the test for what a material consideration might be in the determination of a planning application. And so effectively just saying that the tests are the same for conditions and material considerations. And at 34, that's where the point is made. And those conditions are the ones that we've already touched on this morning, or your lordships have already touched on this morning with Mr Beglin, that they must be necessary, reasonable, and reasonably related to the development in question. And we see that reflected in all the cases, including the Penwith judgment. So that again is just by way of overarching principle to bear in mind, and how the judge below applied it to the case, to our case. So that's the point. The point on right. And then I just wanted to touch, if we may, again on the guidance, and not least on paragraph 183, which I handed up to your lordships this morning, which is at, well, it's now hopefully just behind page 44 of the core bundle, which was the continuation of the relevant section of the MPPF. It's 183, so I hope it should be behind your page 44 of the core bundle. Yeah. And the relevance, the defendant relies on this, and it says that the focus of planning policies and decisions should be on whether proposed development is an acceptable use of land, rather than.
So where are you reading from?
So I'm reading from paragraph 183.
183.
Yes, it's not a long passage, so I just thought I'd read it. It's the focus of planning policies and decisions should be on whether proposed development is an acceptable use of land, rather than the control of processes or emissions where these are subject to separate pollution control regimes. Planning decisions should assume that those regimes or these regimes will operate effectively. So that's the relevant part.
How does that fit with the authority that Mr Beglan cited to us?
Sorry, which one?
The one that said you couldn't necessarily assume such things. Which one was it? What was it, Hopkins? Yeah.
Hopkins. I didn't understand that authority saying you couldn't assume that. It says that there's no obligation not to consider it.
As I'd read Hopkins, what it prevented you from doing was saying, well, just because it's covered by environment, I can't look at it. I can look at it. But having regard to this guidance, I might be perfectly entitled to say, well, pollution's a matter for the Environment Agency.
That's right. That's correct. Exactly. So the key point, my lord, if I can build on that point, is that it's context specific, and that whether, in fact, the operation of another regime is relevant or not plays into, if you like, the matrix of considerations that forms or undergirds, if you like, a planning judgment that might be formed as to the relevance of a particular issue, and in this case it's contamination or not, in relation to the proposed wall. And I focus, for the purposes of this paragraph at least, just on the contamination issue, not the intensification issue, which is as it was, separate conceptually. So that's the MPPF, and with that in mind, my lords, I think it's probably useful for us to just draw out for the defendant's case the relevant parts we say that matter in the local and national guidance. Not spending a long time on this, obviously your lordships have read it, and you went through with Mr Beglan earlier, but just for your notes, and obviously if any of you, your lordships, wish to ask a question about them. First of all, the local guidance, which begins at page 62 of the supplementary bundle behind internal tab 7 of tab 7 in my supplementary bundle. So it's page 62 of the bundle, that's where it begins. And page 66 is where it begins in earnest, with the actual guidance. And it's important to note, obviously the focus, I think, of to some degree this morning was on whether this applies just to residential development. And your lordships have picked up the point made, I think, by Mr Howell, QC, Deputy Judge Howell, QC, that in his view it had referred or had related, to residential development. Clearly, 2.2 does, as my learned friend said earlier, suggest that there's a particular sensitivity in relation to residential development. But I think it's also important in the context of the comments of the judge below to point out 1.1, which does, as it were, set the parameters around, well, effectively brownfield land. That this is to the aim of bringing derelict land back into use.
Well, I think what can fairly be said, it doesn't seem to be focusing particularly on the position of a boundary wall.
No, I mean, obviously that's the defendant's point. So that it may well be more broad than simply residential development, but it as your lordship says, it doesn't in any clear or obvious way bear on the proposed development in this case. It's also important just to note, and this is a principle accepted by my learned friend and repeated by him, but that is stated in paragraph 2.2, or rather 2.1 and 2.2. That's the principle really of a proportionate approach to applications. So although contamination is widespread, it may not always be present in a form that would pose an unacceptable risk to human health, etc. Therefore, it would be unreasonable to require every application to be supported by an intrusive investigation. And then it goes on in 2.2 to say the Council's requirements to characterise the site of contamination will be proportionate. Again, a very important principle that one sees throughout the policy and guidance of the MPPF and the MPPG as well. So those are the key points to note from the local guidance, my lords. And then if we could go further along to page 82. Here we've got the section, excuse me, on land affected by contamination. It's probably worth pointing out, I don't know, my learned friend was correct to point out this is from the 2014 version. We know that the MPPF was updated in 2018, pre our decision in July 2018. So it may be, and I only just flagged this for your judgment and for your notes, that it may be that this version preceded that. However, I think it would be common ground, and my learned friend will correct me if I'm wrong, that nothing of substance or materiality has changed in the guidance here as compared to any iteration that had subsequently been introduced. There were some changes in July, I think, 2019, but they were later on. But that having been said, on page 83 at the top, we have the passages which we say are very relevant here, obviously reading and or rather expanding in a sense and explaining further the point made at paragraph 183 of the MPPF, which is to attempt to delineate, in a sense, what the appropriate parameters of planning's role might be in relation to these other parallel regimes which operate. And we see, first of all, at the top of 83, when dealing with land that may be affected by contamination, the planning system works alongside a number of other regimes. And then we've got part 2A, which is the part that you have the guidance for, which is effectively backward-looking, and it's effectively a strict liability. It's a statutory regime, but that seeks to impose liability on polluter where contaminated land is found. Then we've got building regulations, which is not strictly in issue here, although it may of course be relevant to the construction of or the erection of a wall. And then we've got the environmental permitting regulations, which is where the Environment Agency comes in. So we have three parallel regimes, all of which are dealing with, to look back at the MPPF, the control of processes the control of processes or emissions, rather than purely the acceptable use of land. So then we've got in paragraph 3, which is the next one down, what is planning's contribution, and we see there a description of what planning can do, and to ensure the perhaps relevant part is to ensure a site is suitable for its new use, and to prevent unacceptable risk from pollution. The implications of contamination for a new development would be considered by the local planning authority to the extent that it is not addressed by other regimes. Now, here, the judge below, again, I think, had the correct construction or interpretation of this guidance, in that it would, to use your lordship's succinct phrase, not bear on the wall, not bear on this development.
Sorry, say it again.
Not bear on this proposed development, this wall. This guidance would not bite on the development here proposed. Then we've got obviously.
Yes, but also in the middle section under what is planning's contribution,
Yes.
last, to ensure a site suitable for its new use, query whether a wall is contemplated, and to prevent unacceptable risk from pollution, the implication of contamination for a new development would be considered by the local planning authority, and then these words, to the extent that it is not addressed by other regimes.
Exactly.
And you would say here, it has been addressed by other regimes.
Yes.
Not the wall as such, but the issue of contamination.
Yes. And I mean, it is an obvious point, but there is no proposed change of use in play here. Obviously, this wall is simply a boundary treatment for an existing and lawful use that's permitted by an extant planning permission. And so, exactly, there's no obvious way in which planning could make an additional contribution within the terms of this guidance.
Yep.
Now, again, we have the section my learned friend, I think, relies on, which is paragraph 7, so that begins at the top of 85. And that is all fine as far as it goes, but again, there's a question mark from the defendant's case. There's a question mark as to how any of the more specific requirements here relate to the particular development proposed. And in particular, we've got the emphasis again on proportionality. So in the middle there, we've got if there is a reason to believe contamination could be an issue. And then we've got developers should provide proportionate but sufficient site investigation information, etc. So that's, again, some key triggers, if you like. There has to be a reason to believe in contamination being an issue, and then there needs to be proportionate but sufficient information and investigation thereafter. So that just is by way of the guidance, the National Planning Practice Guidance, and your lordships will have seen the way that's paragraphs 23 to 25 of the judgment below, which we support. That's probably sufficient on law and guidance and policy, and it's helpful, I think. I don't want to go through all of the documents that were discussed before this morning, but only just draw out a couple of relevant points before we come to the officer report, and then I can obviously make my submissions within the context of the officer report. So the first point to note that I wanted to draw attention to is the forgive me, it's the soil, so the expert soil assessment. Now, just find that. It's behind tab 6, page 51 of the supplementary bundle. Actually, before we get to the soil assessment, I don't think I need to deal in detail with the objection unless your lordships have specific questions about the defendant's approach. But our view about the objection echoes that of the judge below, which is to say that this is a series of complaints and in many questions about the operation of the wider site. But crucially, and if one looks at page 46, possibly is useful to have that open, page 46.
The supplemental or the core?
Sorry, we're in the supplemental bundle now.
Yes.
And at page 46, we've got the list, as it were, the shopping list of objections or points made under technical matters. And we have points 6 and 7 being made in respect of intensification, and points, point 9 in particular about contamination. And we see there that your lordship already drew or asked the question in relation to point 6, where it is said the proposals for a 5 metre high concrete panel fence throughout, but without any reference to how the yard is used or is intended to be used. The increase in height will implicitly allow material intensification of the use, which is not factored into the application. So the defendant submits very strongly that this is an insinuation, effectively. There isn't an evidential point made about a link, a causal link, if you like, between this proposed development, the 5-metre wall, which on most common sense basis would improve the security and the screening of the site and contain it better. There's no evidential point made about a causal link between that development, that wall, and any possible or potential intensification. There are speculations in 7 around the planning statement and this notion that there may be somewhere in the planning history buried, as it were, conditions that apply to the heights that have not been, or that are unearthed or not found. We see later there's no reason in the report, as the judge below found, there's no reason to doubt that the planning officer considered the planning history properly. So again, it's a mere speculation. They haven't actually pointed to a document that shows that there's a requirement that the planning authority is not considering. There is just the suggestion based on this vague comment in the planning statement. So again, there's no hard, concrete basis for that objection in paragraph 7. And then if we go to 9, we see this is the point about contaminated land. And it says this is proven in the attached soil contamination assessment of the 11th of October. It then summarises what's happened, and then it's what the assessment consisted of, and then it says the application involves building in and on the contaminated land stated as fact, and then it says hence as a matter of law the application must be supported by targeted contamination reports, etc. That refers back presumably to their reading of the guidance that we've just looked at. And in the absence of any such assessment, the planning application would be fatally flawed. Now, that's important to look at in advance of just looking then at the soil assessment. Before turning to that, however, on page 48, we've got further speculations, particularly in the middle of the page. On behalf of my clients, we've got this assertion again. I submit that the proposed wall is nothing more than a stalking horse to allow Benfleet Scrap to store and process more metal, etc. Again, there's an assertion there. There's not hard evidence about why that might be the case, and there's no causal link pointed to as to why it should be the case. And my learned friend said this morning, what more could they have done but put these objections in and let the local planning authority consider them, and then consider in his terms thoroughly the possibility that they might have something to them. But there is more that they could have done. They could have, for example, shown examples where intensification occurred, shown examples where waste facilities in particular intensified if they could be found, and maybe this is why they're not there, but if they could be found, examples of waste facilities that had intensified as a result of boundary treatment. And that is the sort of evidence one might expect for this type of consideration to have been properly grounded. Again, this point about contamination is made without evidence. So we go then to the soil assessment report, which begins at 51. The first point to note then on page 51 is the date, which is the 11th of October, 2018. So we know it postdates the planning application, and it predates the objections that were made. And in that context, what is really striking about the soil assessment report is that no mention at all is made of the proposed development. There's nothing in this report that bears on that proposed development. It's not as though the consultancy says, or the consultants say on the basis of what they discover, this proposed development must not go ahead because X, Y, Z points about it would materially increase the risk of contamination.
But that wouldn't really be for the consultants anyway. They're there to measure what's in the soil. And, I mean, there's nothing more irritating than to see experts straying beyond their proper boundaries.
Well, my lord, I absolutely would agree with that. On the other hand, they are the experts on contamination.
Yeah.
And so one ought to, had there been a real complaint about the construction or the erection of the wall in contamination terms, one would have expected the planning consultants to go back to the soil assessment consultants and say, look, this is what's proposed. You've made a very good report with, thank you very much. You've shown that there's some pollutants in the soil nearby the site. And you've clearly given us pause for thought regarding our own proposed development on our own site and the problems of contamination. But please, could you comment on what's proposed? Is there anything we should be saying about what the risk might be in relation to construction of the wall? And there are expert planning consultants and expert contamination experts, and one ought to have seen some comment marrying the two pieces of evidence together rather than an assertion that doesn't actually connect to what is being found in the conclusions of this report at page 57.
Did you accept Mr. Beglin's proposition that the inevitable inference from this report was that the contaminants had come from your land?
As your lordship said, there's a mention of some hard standing potential, but of course it looks likely, or the most likely cause does seem to be the waste facility, and one perhaps would expect that given the types of operations going on. On the other hand, again, perhaps telling in what my learned friend said earlier on, there was a complaint to the Environment Agency, and it's perhaps important to note that nothing was actioned by the Environment Agency. Not to say that they should be performing planning functions, but if there's an issue of substance regarding contamination, then one would have thought that the Environment Agency would be interested in it and would be taking some action, but none has been taken. But to return to this report, we get in the conclusion at 9, and the bottom of 57, paragraph 1 there, we again see that this has directed this report towards quite properly, no doubt it's the scope of their instructions, but it's directed towards the proposed development that they're seeking to put it on their site. And no doubt, it should be also said, that the local planning authority will take very seriously, when it comes to it, consideration of any potential issues in this regard when a proposal comes forward for development on that site, and that may well result in investigation of one sort or another, subject to what's found.
Well, one might take the view that this report, if anything, could be read as strongly supporting having a good wall.
Yes, my lord. Yeah, I mean, absolutely. It has been somewhat confusing for the local planning authority.
This was provided to the planning officer.
Yes, with the objection.
With the objection, but with no further explanation.
Well, the explanation comes in insofar as it is an explanation.
The objection
comes in the objection letter. Yeah.
Okay.
But it was before the planning officer. So my lords, that's what we say on the soil assessment, and I don't think, unless your lordships have specific questions. Oh, just one final document we do need to go to before the report. Well, actually, no. It makes sense to go to the officer report first, and then we'll deal with the decision makers. So, if we can go then to the report itself, the officer report at 234. Excuse me. So my lords will have read this, obviously, and the report begins with all of the usual information, description of the site, description of the proposed development and the relevant history, a potential local plan allocation as an employment site, relevant policies, notes the MPPF, and notes that point I was just alluding to, which is that there was a new MPPF introduced in July 2018, which is the one that we've looked at. Then the plan policies and the consultation responses. Importantly, we've got the environmental health response, but then we've got the neighbour notification recorded and a summary there of the 30th of October representations that were made. So we know, pausing there, that they've been read, they've been looked at by the planning officer, and we know that therefore he's considered them. Then we've got the comments, and this is something obviously my learned friend has made much of. The first part of the comment is the running of the scrap business is not a matter for consideration in the context of this application. It's important, I think, to note the second half of that sentence. This isn't a categorical statement saying that it's never going to be appropriate to consider the running of the scrap business at all in any possible application. It's in the context of this particular application for the boundary wall. So we know that already the analysis is being limited to the specific context of this application. Then the officer goes on to say, Mr. Zamet, the application before the local planning authorities for a boundary treatment and the considerations when dealing with the impact of the wall and its effect on any nearby residents. So he's identified there the main issues as he sees it for consideration. Now, again, pausing there before we come to the top of page 235, we can see that a judgment is being formed. It's not yet formed in total because we must bear in mind that reports need to be read as a whole. So we read them all. We're not construing a statute, as your lordships know full well. We're reading everything as a whole. So this is the formation of a judgment. And we see that he's identified the main issues and narrowed it to the specific context.
And
then,
sorry to interrupt, but
yes.
just before we leave the bottom page, the effect on nearby residents has been noted in the paragraph above to be noise, which obviously relates to use, intensification of use of the thing. So I'm not sure it's even fair to say that intensification is completely out of the picture.
Well, no, I mean, intensification may produce more noise.
Yeah.
That's certainly possible, yes. So in that sense, it's not been totally cast
because
out.
that is, I mean, the visual effect is obviously one thing, but the effect of noise relates to the operation of the site. And that's the only other effect that it could have on the neighbours, according to what we've got.
Yes, no, I would agree with that. And it's also probably useful to note here, there was a lot of discussion of what the Environment Agency may or may not do in that parallel aspect, if you like, to this decision. The other issue, which wasn't touched on this morning but is important as well, is that, of course, in the officer's mind is if there's a material change of use, or if there's intensification, such as to become a material change of use, that's a breach of planning control that can be enforced against. So that's within the planning sphere, as it were, which is, so in the sense that there is a concern potentially about intensification, part of what's happening in the back of a planning officer's mind is that it can be enforced against.
Well, the indications are that for intensification to amount to a material change of use is a pretty rare thing.
Yeah, there has to be a change in the nature of the use.
It's quite an extreme situation.
It is, yeah.
I think one of the points Mr. Beglan makes is if you just take what's said at the foot of page 234, in effect, I think he would say, is the planning officer has already decided what the considerations are, and they are those two. And as Mr. Beglan would say, he's already starting to close his mind the possibility of intensification being a consideration.
Well,
And I'm putting it in my words, not his, but I think that's one of his complaints at this stage of the report.
well, yes. I mean, I know that's I know that's my learned friend's complaint. I don't agree that that's true to the extent that we then have the subsequent.
Well, then you get
which
the main issues are, which slightly rose back from that.
Yes, I mean the main issues are not the only issues. I mean,
Yes.
I'm not saying that. I mean, I don't agree that he's closed his mind to intensification. I don't agree that that's the correct reading for that first sentence there, where it says the running of the scrap business is not a matter for consideration in the context of this application. Except to note that we must bear in mind the test for material considerations and conditions, which is that development has to be, a consideration has to be reasonably related to the development under consideration. And so again, by reference to the objections which we know have been taken into account because they're referred to directly, and this is the response to them, there's nothing in those objections that have established any causal link, as opposed to a mere assertion, as to the likelihood or even the potential or possibility for intensification. So I don't say that he's closed his mind to intensification. I do say that the officers there responding directly to what is contained in the representations, and then we know, which we're coming to, but at the top of 236 he then does deal with in any event.
Well, you might also say at the top of page 235, if the business is causing environmental pollution, the joint owner could report this to environment agent.
Yes,
So you
absolutely.
say that's also of a pattern with
Absolutely.
not shutting his mind to it, but just saying
No.
there is another remedy.
Definitely.
And you say that's relevant because a planning condition has to be necessary.
Yes, exactly. Exactly. It must be necessary. And in terms of the contamination side of the equation, if you like, then certainly that comment at the top of 235 is crucial. It's saying, I'm looking at this, I can't, effectively, there isn't enough to ground a serious problem in my mind with the contamination issue, and if there is a problem, as your lordship has pointed out and as it says in the report, then the adjoining landowner could report this to the Environment Agency, which, as we've established since this case began, that is exactly what's happened, and the Environment Agency hasn't taken it any further. We then have the detailed consideration or the evaluation of the visual impact elements and the green belt. Most of that is not strictly relevant for our purposes, though it was a ground of challenge earlier on in the case. And clearly we then come to the important paragraph, again, which grounds my learned friend's complaints about possible imposition of a condition. Bearing in mind we shouldn't take this in any sense as an exercise in statutory construction or exegesis. It probably is worth just focusing on it. So for a bit, the first sentence, it is noted that the adjoining landowner fears that the provision of this wall may simply enable the scrapyard to score scrap to ever greater heights, worse than the existing problems of scrap and pollutants escaping onto his land. Absolutely is a consideration, if you like, of what is said in those representations, what is said in those objections. It is, in a sense, a recognition of what is said in those representations. In that sense, it is being considered. It may not be. Well, we know ultimately it's not being attributed much weight, if any. We go on then to say, however, there's no condition on the planning permission for use of the site for waste recycling and recovery, and there's a waste transfer station that limits the height to which scrap may be stored. Well, that's a statement of fact. We know that. And then it says, while it may have been prudent to impose such a condition, the benefit of hindsight, the simple fact is that there's no planning mechanism to prevent the operator of the site storing scrap to the height he wishes, regardless of whether this application is approved. Again, my lords, we say this is actually quite a clear, again, statement of fact. It may have been prudent in 2002 to consider some sort of condition that limits operation. that's not possible now because we already understand the thrust, if you like, of how the officers viewing this application by saying that wider operation that is not connected to this development, i.e. that the erection of the wall doesn't ground any planning mechanism that might be introduced now. I mean, that would be taking a leap.
It's this last sentence of that paragraph which is the whole key to this appeal, as the appellant's argument is. And I think what the debate is, there was a planning mechanism available, namely a Penrith kind of approach. And his argument is that by putting it this way, the officer has simply discounted that as a possibility.
And we would say that that's not possible because actually there isn't a Penrith solution in this case because there's no link. There's no link between a boundary wall and the question of either intensification, which is never anywhere shown or proven by anyone. Another important aspect which the judge below noted, and we've put in submissions throughout, is no condition was proposed. No condition was proposed by the objector.
But as I understand it, I think Mr. Peregrine is now saying really this should have been deferred for further consideration and investigation.
Well, no, I understand. I mean, of course, if it's the normal course of events, if a local planning authority needs further information, they will make that request and they will defer consideration pending the outcome of the obtaining of further information where it's relevant. But here, if the officer formed the judgment, which he clearly has here, that there is no need for a condition, he says later that no conditions are necessary, bearing in mind the fact that you can only impose conditions that meet the tests. So you can't just impose any condition. And we would say actually a Penrith condition wouldn't have been appropriate or possible here because in fact there's no connection being shown by anyone, but especially particularly by this objector. There's been no connection shown between why the boundary wall would produce further intensification.
Well,
the boundary wall's 5
think
metres.
Another point that I think Mr. Beglan seeks to make is that the officer expressed by the objector, and as you say, that can't be a visual impact point only, it's obviously going wider than that. But there's no finding or indication by the planning officer that those fears are unsubstantiated and speculative.
Well,
and like Ms. Beglan said, well, the judge has simply substituted his own view on that for that of the planning officer, which wasn't expressed.
Well, again, that's be a reasons point, but we don't agree with that because we don't. Well, actually, the law, if one looks at law regarding how one deals with these types of officer reports, there's no requirement to respond to every particularise every material consideration that may be being considered. The duty is actually only to show the main reasons why you've come to a decision, to show them adequately, intelligently and clearly enough. It would only be the case that my learned friend was right if there was some reason why, or some trigger, effectively, why this goes from being material consideration to one that should be given great weight, or given some weight, or enough weight to make a difference. As my learned friend says, he wouldn't need to show that it would be the decision he wants, but it would have to have made a difference. And here, there's nothing to ground that. There's nothing in the evidence that was before the decision maker, or in the assertions that were put forward by the objector in their representations. It was just assertion. I mean, if we step back again to the
suppose, can I give an example which I think one of my lords has mentioned, if not in court to me, but supposing someone says, with regard to development, I saw 2 bats flying along that particular boundary. It's the only person out of 100 who says that. Is the council then under a duty to investigate, or what?
Well, we'd have to be considering the policies, the specific policies in relation to
No, but it's just
to bats.
sometimes not every single kind of complaint raised is going to justify on grounds of proportionality.
Well, that's right. That's right.
A detailed examination.
Absolutely. Yeah, thinking in terms of the proportionate approach that must be taken, and the fact ultimately that this is a waste transfer site, and that there are likely to be contaminants present. There does need to be shown, however, in that context, why the erection of what, on most common sense, on the common sense point with which your lordships began this morning, would seem to be an improvement, effectively, i.e. you're going to build a wall that will screen and contain the operations even more effectively, both for greenbelt purposes but also for potentially other purposes, in terms of keeping things inside the site. One has to show how and why that would make any difference at all to the operations of the site and that would ground a complaint about intensification. They're entitled, not through a planning control, admittedly, but they are entitled to stack the cars or the scrap metal as high as they like in planning terms, but certainly up to 5 metres within the terms of their environmental licence permit. They do so anyway on the appellant's own evidence and often exceed that. Why in that context is there any reason to suspect that intensification is going to be a problem, unless it's shown that it would be by someone? But no one has shown that. I mean, a planning officer can't be expected to respond to a notional assertion. That would be unduly onerous, particularly in the context of an application like this, where this is in any event a delegated decision communicated by the planning officer to the expert. We're not dealing with a major or significant development with potentially hugely significant environmental impacts in that sense. And it's, again, to go down the page, we do see that conditions and the possibility of the imposition of a condition was considered by the officer, and he considered that none were necessary. It's probably fair to note that he's saying that in the context of the landscape aspects as well, or rather he says that in the next line, doesn't he? But it's clear that he's got the test in mind for conditions and the imposition of conditions. And it's in the defendant's submission, it's impossible to read that passage when the report is read as a whole as directing himself that he has no power where power exists to impose a condition. That there are constraints on the ability to impose conditions, and those come about through the tests for conditions. And the Penwith case, we would say, is inapposite. You can't read that across to this situation for the reasons that the Lordship is canvassing and the reasons that we've said in our skeleton argument. This isn't an application that's obviously for intensification. Even if one looks at the finer, perhaps finer balanced case of Evans, which my learned friend relies on, where it must be remembered that actually there was, again, the claimant didn't succeed, but the development in that case was, there was an argument there about, a slightly more finely balanced argument about whether there would be intensification or not. But again, it was much more explicit that there would be the potential for intensification, and the possibility of it was much more thoroughly examined. Here, there's nothing that is so obvious from the proposal itself to suggest that it facilitates or enables intensification. And so we say one shouldn't make that leap in judgment, or that inference, which does require a leap that's not justified on the language of the report.
Yes?
So, my Lord,
what do you say about the last paragraph at the foot of page 236?
My Lord, well, that again just reiterates the specific consideration given, the detailed representations made, and the reasoning exercise that was clearly undertaken to say that those objections were outweighed in the decision maker's mind, such that he recommended approval of the application. And my learned friend was trying to say that that's a standard add-on, as it were. Well, the standard add-on.
You get standard guff under the heading informative, don't you?
Well, that's the standard.
That's
I was
the
about to
standard.
say that's the standard.
That's the wholly generalised one. But you say this one is specifically refers to the objection itself.
Yes, yes, and it reflects. It's not in that sense. That's not strange reading. I mean, that reflects what's said on page 234. So it's consistent in that sense. So, my Lord, I've covered much of points I wanted to make on the substance. I just want to go through just to double check if I've made the points I need to. Right. This is probably the moment just to turn to the decision notice, which is a few pages on 238. And important to note here, one of the concerns that Mr. Justice Holgate referred to in granting permission at the oral renewal hearing.
Well, we've seen no transcript only judgment from Mr. Justice Holgate.
No, indeed. So I just want. Well, I'm happy to make this comment. Absolutely.
So what's the point you're making?
But the point is that there was a concern earlier on as to whether this, as it were, allowed for an unlimited wall, and actually the permission makes very clear, if one looks at 238. It grants permission for the said development in accordance with the approved plans listed below. And then we've got 785403, and it's just to note for your notes and to draw your Lordship's attention to it, the plan comes thereafter on 244, is that plan 785403, which indicates clearly the 5 metre height and construction and how it's to be, its dimensions effectively, which would of course allow. Well, it means that if wall was built higher or something, or not in accordance with that plan, then that would ground the potential enforcement as well, planning enforcement. So, my Lord, I think I just want to say by way of a concluding submission, I suppose, that or final submission, before I just double check any points I need to respond to that were made this morning. But the intensity of an inquiry into a potential material consideration, or something that might flow from material consideration, such as contamination, for example, or intensification, must flow from the judgment that's made by the planning judgment that's made by the decision maker on materiality. So it's no good, as my learned friend does repeatedly, to posit alternative judgments that may have been made by a decision maker, as in fact some of the cases that he relies on also show, such as Evans. He needs to actually show that the judgment that was made, the judgment that was reached, which we've gone through in the report, was irrational.
Well, I don't think Mr. Beglan is getting at the intensity of the inquiry. What he's saying is there was no inquiry because the planning officer wrongly thought that you could not use planning permission to impose planning restrictions because he didn't have in mind Penrith.
Yes, but
Mr. Beglin's not talking about the lack of intensive inquiry. He's saying there wasn't one just because of the wrong perception of the officer.
well, if you decide that, forgive me, Mr. Beglin may well be saying that for the reasons I've said. We don't agree with that. Obviously.
Absolutely.
I'm saying that the only reason why the decision maker, the officer in this case, should have been required to undertake a more intensive investigation of the contamination issue, for example, would be were he to consider that there was a genuine issue there or a genuine risk. The fact is he's entitled as a decision maker to form a judgment about the materiality, not whether contamination is in principle capable of being material, but rather is it...
You mean intensification?
Well, either, but I was talking about contamination actually,
Right.
either of them. They're both capable of being material considerations, and I don't think any planning officer who, they're pretty basic concepts in planning, but the jump from being capable of being material to being material in a particular case, and then the intensity with which one has to address a material consideration, relates to the judgment that's made in relation to the materiality of the issue. That's the point. And once a judgment has been made and a planning judgment has been made, and we say that there clearly is one, there's no reference in there to saying that there's no power to impose a condition. Rather, what there is a statement of fact about the planning history of the site. And when then one bears in mind what is actually in a planning decision maker's head in terms of what the tests are for imposing conditions, that passage in the officer report is readily comprehensible and readily understood, not as a direction about a power to impose conditions, but rather as an application of judgment to the facts of this case. So, my lord, I just want to double check, because I'd made a note of a few points that were made this morning, just because obviously Mr. Beglin will come back, and I just want to make sure I've covered what I need to. Mr. Beglin said this morning, you'll remember this, where I think you had, as it were, with him, reached the crux of the matter, and you tried to, your lordships had said, what's the legal test that needs to be applied here? Is raising a concern enough? And Mr. Beglin said, yes, raising concern was enough. But and that then needed to be thought about or considered or investigated further. The point we would make is that actually was noted, it was considered, the concern was made, it was noted in the report, it was given consideration, as is reflected in the passages we've gone through. And so, insofar as the concern was raised, the officers formed the view and taken the view that he's taken in respect of those representations. It's a small point, but I think there was a brief mention of whether there was any indication in the officer report as to whether the officer had the environmental licence in his mind. I mean, the only point I would make on that is that by expressing it in the way that he did, that there's no planning mechanism, I think that the implication may be fairly drawn that he had in mind that there was an environmental constraint. But I say no, I don't put that very highly. I just say that the delineation...
Well, one might infer that from the express reference to
the Environment Agency.
being able to refer it to the Environment Agency.
Exactly.
And everyone knows that you need, for a waste site like this, you need a permit.
Yeah. Yeah, but I mean, in terms of whether this specific 5 metre, requirement of the licence was in mind, I mean, we can't go that high, but we can infer from what's said in the report that that was part of the consideration. So, my lords, that's all I wish to say. The claim is legally flawed and flawed, we say, because it does rely on an unsubstantiated claim, fundamentally, about both intensification and the particular relationship of contamination with this proposal, such that any action should have flowed from that. So those are...
What it really comes down to is, how does one read the decision letter?
Yes, well, I hope your lordships have our points on that.
But it does come down to that, doesn't it?
Absolutely.
Ultimately, is how does one read the decision letter?
Absolutely. Yeah.
And you say black, and Mr. Beglin says white.
We do, and the judge below says
and we'll have
black
to
too.
and we'll have to sort it out, won't we? Yes. Anything else, Mr.
No, those are all submissions. Thank you. I'll just double check. Sorry, I should double check. Nothing further. Thank you very much.
No, thanks.
Thank you very much indeed. Yes, Mr. Beglin.
My lord, I certainly can't improve my lord's summary of our respective positions at the bar. Can I just take some short points by way of reply? In relation to the suggestion about the level of information that was before the local planning authority, we say, in an integral part of our case, is that they ought to have made further inquiries based on the material contained in the objection. But it's not just the material contained in the objection, because as the skeletons both below and in this court have pointed out, there was material which appears on the tabs of the local planning authority's own electronic filing system for planning applications, and that's at page P337 in the supplemental bundle. And it's not a very detailed note, but it relates to 16 Manor Trading Estate. Gives the name, constraint type, potentially contaminated land. So whenever planning applications are being dealt with, there's now a fairly standard way of displaying those on web pages that my lords may be familiar with. And there tends to be a constraints tab that you can access in relation to the planning history. And the constraint type here was potentially contaminated land for the reasons that are set out there. So what that feeds back to is what the proper approach to box 6 should have been. Because part of my learned friend's case is to say, well, there was nothing to alert the local planning authority to the fact that box 6 required further steps to be taken. And in my submission, there are 2 problems with that. The first is that our objection was certainly sufficient for an officer to look at the material and say, well, there may well be a planning judgment to be made here about the risk of contamination to a part of this site. And it doesn't have to be knowledge of contamination. Box 6 works through the logical alternatives. And the second point is, even on the authority's apparently own records, this has been flagged by them. I appreciate the date that's on the webpage, because that was when it was printed, but there's nothing to indicate that this wasn't there at the time that this, which was the latest planning application, was being dealt with, and it's been in the public domain between the 2 parties for an extended period of time. So that goes back into how box 6 should have been operated. And of course, the environmental health officer who gave some feedback in relation to the issue of noise didn't provide any feedback in relation to the issue of contamination. If box 6 had been complied with here, there would have been a desk study. There potentially would have been more, depending on what the local planning authority thought was proportionate in order to deal with this issue. They would have needed to have exercised their judgment in that respect. So that's the first.
Where did we get the noise report?
It's at the start of the officer's report. So if my lord...
Have we got in the papers?
I'm not sure we've got any primary material. The consultation response, if that's what my lord is looking for from environmental health, I don't think we have actually got that in the papers.
Okay.
But there's no indication in the summary of the consultation response that it sought in any way to address the issue of contamination. And indeed, for what it's worth, it's not clear that the officer responding to the consultation necessarily saw the letter of objection. They're relying on historical records of what's come into the Environmental Health Department. So that's the first point. The second point relates to the conditions within the report. And as my lord indicated, it's all come down to whether or not in the report the decision maker had said that they were going to leave the issue of intensification entirely out of account, that it was going to be on one side because there was no mechanism to deal with it. If the conclusion is there's no mechanism to deal with it, then it's utterly unsurprising that in the report there is no reference to trying to impose a condition in that respect. That's entirely logically consistent with the idea that it's simply not something that in the context of this application the planning system provides a solution for. So the absence of a condition in that part of the discussion doesn't assist my learned friend's case. What it does show is that at no stage did the officer, apparently within this report, say, right, well, perhaps there is an issue in relation to contamination that I might deal with, but when I apply the condition tests, I am not satisfied as a matter of my own judgment that it would be appropriate to impose a condition in relation to contamination, even if it was a condition requiring a scheme to be worked up. That sort of discussion could have appeared in an officer report if the officer had said, well, I see that I can address this issue, but as a matter of the weight that I give to it and the seriousness of the implications, I don't think it's necessary to impose a condition.
So I'm sorry to nibble away at a point which I raised this morning, but I'd rather understood you ultimately to say this morning that really it would be very difficult to formulate a relevant condition, and probably what was needed was simply to adjourn for further investigation. Is that your position?
Yes.
That this wasn't really appropriate for a condition as such, as matters stood?
Absolutely. There wasn't enough information, we would say, to formulate the condition clearly. But the reason...
So the matter should have been adjourned for further investigation, deferred for further investigation?
Yes. That would be, as it were, position one. But if the officer elects to continue, then what you can't take from this report, which my learned friend invites you to take from this report, is that there's something in the discussion on conditions that's consistent with his position, because the discussion there is equally consistent with my position, which is that by that stage the officer had said there's no planning mechanism to allow me to address this. And probably means a condition if it means anything. So in those circumstances, it's not surprising the officer didn't go back to condition. In fact, my submission would be that the absence of any discussion of a potential condition here is more consistent with our case.
So just to repeat, you're not suggesting any formula for the kind of condition that might have been imposed at that time?
As a secondary position, then the kind of condition that could have been imposed would be along the lines of the model conditions requiring investigation, assessment and evaluation of the risk of contamination. So for example, in the absence of a desk study, requiring there to be a desk study, requiring there to be a walkover, requiring consideration of whether or not more would be needed to have a proportionate evidence base to deal with the point about intensification and contamination potentially arising from that intensification. In relation to paragraph 183 of the MPPF, of course, that is guidance to be applied. It has a particular focus, but it doesn't cut it as 183 says. It's dealing with the focus of planning policies and decisions. It's not taking away from any of the case law says that it is open to local planning authorities to consider these sorts of questions. They're not obliged to, necessarily, if there is an alternative scheme in place. But they do have to address whether it's something they ought to deal with.
But the officer can be taken to have had that provision in mind. He doesn't have to spell it out, and therefore it makes it entirely legitimate and relevant and to have regard to the powers available to the Environment Agency, doesn't it?
Yes, it's in the generality, yes, and it could have been more specific if there had been specific discussion of the permit here, and it's not clear the officer was alive to the terms of the permit, at least. If there was more discussion of the terms of the permit and saying, well, this is the reason why I don't have to think about a planning condition here, because I've thought about whether there's a need for a planning condition, there is a mechanism I could use, but I don't need to use it in this case, and it's not appropriate to use it because, in fact, there's a better way of resolving this, and because I know about the terms of the permit, I can record in my report what that is. It's the presence of the limitation in the permit. That could have been done, and if that was the way that the officer was really dealing with this issue in his own mind, then one might have expected that to have been articulated. What was articulated here was a far more summary point, and as I say, in my submission it is important to look at where that occurs within the report. It's before the evaluation, but it's after the point where the officer has concluded, or set out at least, that the running of the scrap business in every feature that we identified, because as was the principal objection, the running of the scrap business is simply not for me. So that includes the point about intensification, which we spent some time discussing. And it's on that basis that the officer says, well, there is potentially an alternative. It's not on the informed basis of, I can do something about this, but I don't need to do something about this because there's a better mechanism available.
Again, to raise you the point which I raised this morning, but I'm going to raise again. Let it be supposed that the conditions of the environmental permit had always been scrupulously complied with, and let it be supposed that it was known, let it be supposed that the Environmental Agency would come down like a ton of bricks on any breach. Yeah? Valid grounds for objection still?
But first of all, my lord, that's not this case because there,
no, I
there is
said let it be supposed.
Yes.
I'm asking you to let it be supposed that there has been scrupulous compliance with the permit, and let it be supposed the Environment Agency would immediately hit any breach. Would you then have a valid objection still of the kind you raised?
Potentially, and the reason is, without trying to get too far into the detail of a situation that we're making certain assumptions about, but we otherwise don't know about analysing the detail of. It might be the case in our minds that at that stage the changes in the boundary that are proposed are such that for the first time it looks likely that there might be a breach of that term. So that is a logical case where we might still maintain, and might successfully maintain, an objection on that basis, depending on what the planning officer thought of it. But what we have scrupulously in this claim tried not to do is put ourselves into the shoes of the local authority decision maker, because it's not a case where we say, or can fairly say, we think the decision maker should have been driven to conclusion X or driven to conclusion Y. What we say is that the process needs to be followed in a lawful way. And so part of what comes from that is that we're not saying that any particular result should necessarily arrive. Those will all be matters of judgment for the authority.
But you're not saying this decision was perverse,
Indeed.
and that there was only one rational answer.
No, I could not fairly say that. But what we submit we can properly say about this is that on a fair reading of the report as a whole, when we get to those critical lines that my lord has identified, we have an apparent acceptance of the position we're describing, the position we're describing is set out. There is no indication there that the reporting officer disagrees either as a matter of fact or as a matter of logic with the approach we've taken. And then what happens next is not anything that might mitigate, compensate or avoid that in terms of planning hierarchy, but what the officer says as the response to this point is there is no condition there at the moment. It might have been a good idea to do it historically, but there is no mechanism to do it now. That's the response that is given. And that's not a response saying we think the complaints are overblown or we think there's a better way of dealing with it. We submit that's a clear response, and it's simply a mistaken response because my Lord indicates that Penwith may not have been at the planning officer's left arm.
It may have been at his right arm. We don't know. You don't know?
No, we don't know. But it's explicable on that basis, and very clearly on that basis.
You said that about 7 times now.
I'm sorry, Mel, I missed what.
You said that about 7 times now.
Yeah,
I mean, you are in reply.
Yes, I will move on. My Lord, then can I just invite my Lords to note that in relation to the points of distinction that we did draw between whether or not this might have been an appropriate case for the Environment Agency to deal with, or the local planning authority, those are set out at paragraphs 59 to 61 of my skeleton argument, where we raise 5 reasons which we say are legitimate factors that if the authority had considered in an active way whether or not the correct response here was to impose a condition themselves or for another agency to do it, those are 5 factors they ought to have taken into account. And my Lord came back in discussion with my learned friend to a point that was raised with me about a good wall. Well, but part of the answer to that, we say, apart from the answer that I've given my Lord on a number of occasions about that being for the judgment of the local authority, but a good wall would be a wall that had a sufficient analysis of the contamination issues supplementing it so that the actual construction of the wall did the most that it could do to reduce potential levels of contamination coming across to our land. And my Lord's seen the photographs, both of what was happening before the wall was there and indeed after the wall was there. And one can form a view insofar as it's necessary to do so.
Well, the logic of your argument is the wall needed to be lower than 5 metres. That's the logic of your argument.
Not necessarily.
No, we say not necessarily, but that's the reality. That's the reality.
Well, no, there are other ways of dealing with the issue. Reducing the wall would be one potential way. Having a condition relating to the way that the site operates might be another way. Having a scheme which would allow for proper assessment of the risk of contamination so that the boundary structure could be constructed in a way that it was essentially impermeable to contaminants might be a third way. So there are various ways that the authority...
Impermeable to contaminants, that's a new one, isn't it?
What a way of constructing the wall will reduce the risk of contamination to the lowest potential level.
You see, we seem to be sort of shifting between contamination and intensification. I know there's a link, but I'm getting a little unsure which is the complaint now. You're now talking about impermeability of the wall. That's not the intensification point as such.
No, it's not, but it could be a bit... My Lord asked me about the various solutions there might be.
You're throwing up so many balls in the air.
But in response to my Lord's suggestion, but my primary position is none of this is for us to decide, it's for the local authority to decide. But my Lord asks the question, so I'm doing my best to field it. And in that respect, one of the ways that it might be fielded is by having a wall that is constructed in such a way as to reduce the contamination to the lowest practical level. And yes, if that could be a condition imposed on the basis that there is intensification, but that might actually improve over time the baseline from where it is at the moment. That happens on occasion with the imposition of conditions. You end up with a situation that's actually better than the one that you had before. My Lord Justice Dingemans raised a point in relation to noise being discussed, and noise is discussed within the report, and that's as part of a specific reaction to what Environmental Health did say in their consultation response. And when my lords go back to read the judgment, you'll see, the decision, you'll see that the decision dealt with the issue of noise on a quite different basis, that actually the presence of this wall was capable of improving the situation in that respect.
A sort of remediation measure. Yeah.
Yes. So there's a difference there in terms of the way that it was assessed. Environmental Health did have an input on that. The officer did reach a specific view in relation to that planning harm. That is in contrast, we would say, quite markedly in contrast to the approach that was taken in relation to our issue, where what was said as well, there's no planning mechanism that might help on the issue that's been identified in relation to contamination. And again, if one comes back to another paragraph that the court has drawn attention to at the foot of page 236, which I have said is a relatively standard passage within reports of this type, of course tailored to specific documents that may be put into a particular application. But that paragraph cannot assist the local planning authority if the court agrees with my principal point, because if the court agrees with my principal point, it's neither here nor there. Well, I'm very grateful. Apologies for the repetition.
May I just ask one question in relation to the findings of fact that were made below? Paragraph 34 of the judgment below, which is page 73 of the bundle. I mean, what the judge says is that there is no evidence at all to support it in relation to intensification. Are we entitled, just because we might take a different view of the materials, just to revisit that finding?
Yes, because it's a matter for this court's assessment as to what the objection disclosed, and the court has my position about it, that it disclosed enough, certainly in conjunction with Box 6 and so on, that investigation was required. That the judge there was going farther than he needed to go in order to decide the case. And part of the criticism of the learned judge in the grounds of appeal was that he had stepped into the shoes of decision maker, essentially. And so to the extent that that was something for which permission was given on the basis of the skeleton argument that was before Lord Justice Lewis, and I say that's something that this court can legitimately entertain at this stage.
No, I'm not saying we can't entertain it, but it's just the approach, because what we've had effectively is the argument at first instance revisited without much about taking apart the findings that the judge made.
Yes, but that's partly as a consequence of the fact that in this court the test for admitting new evidence...
There's a striking feature of your opening submissions to us. You never referred to the judgment once.
No, because it's a running theme through my submissions that the judge overstepped, as it were, what was necessary to deal with this case in a number of respects, and did substitute his own judgments for those of
so if the planning officer had said there's simply no evidence to support this objection, you would have been stuck with it?
That was subject to rationality and other challenges, yes.
But you said the judge couldn't make that finding for himself.
Precisely.
Yeah. But you criticise the judge, I understand, and you've very fairly set it out in your grounds of appeal, but your criticism of the judge is the judge said that there are no grounds for making this criticism of intensification. The judge was doing that because he was saying, rightly or wrongly, that the planning officer was therefore right not to deal with the issue of intensification if he didn't. And I'm worried just on this narrow point about whether really it's just for the Court of Appeal just to revisit the finding that the judge made on the materials before him.
Well, it's one of those cases where you're in exactly the same position as the judge.
That's not good enough for you. Sorry. If it's a matter of evaluation, you have to show that the court below was wrong. We repeatedly get people saying you're in just as good a position as a trial judge, so start all over again. We do not want to work that way. Even in the planning context, we do not work that way.
In relation,
and you're entitled to make the point, this is wrong in law because the judge has entered a field which is not for him to enter. That is a point you're entitled to make. But to ask us just to start afresh and re-evaluating, you cannot do.
But in relation to the judge's assessment, I would make the observation and submission that, of course, what is ultimately under challenge within these proceedings, in the same way as if you're dealing with a housing case or any other kind of case of this kind, is the decision maker's approach to deciding the issues before him or her. And so that is where the focus of the submissions is. Insofar as it is necessary to say that the judge was wrong in relation to his assessment of the evidence about intensification, I do say that. Say the judge went into an area that he didn't actually need to go into to decide the case. But insofar as he made that finding of fact, it was wrong. And I say that it was clearly wrong based on the material that was in front of the authority, contained in the letter of objection, and bearing in mind a point that the judge doesn't appear to have, I would submit the judge has not fully recognised in his judgment, is the inquisitorial nature of this process. We are not approaching the authority with a view to saying, well, here is sufficient evidence on the balance of probabilities that you need to accept the truth of what we're telling you. What we're presented with, and a point that was made to the judge, the point that I just rehearsed with my lord, is that we put the material in front of the officer, and as far as we can ascertain from the officer, he didn't disagree with either the factual analysis or the logical implications of it. He chose to address the matter in a different way. And if my lord agrees with me about that, then what would have happened in this case is that at the very least, further inquiries would have been made. And that would necessarily, if that course had been taken, have impacted on the material that was before the judge.
Thank you.
Grateful.
Thank you very much, Dean Speaker. Thank you both very much, all legal teams, for your helpful oral and written submissions. And people work very hard in this case and appreciate it matters to both sides. We would like to take time to consider the arguments presented to us. We'll send out our judgments in due course. You both know the score, typographical and corrections, not a re-argument. And then hopefully you can agree a minute of order in the light of our decision, and we can hand down without anyone needing to attend.
Sure we will, Mark.
Hope so. Good. Anything else arising, Mr. Begnan?
No,
Mr.
very grateful.
Thank you all very much indeed. Thank you.